Hello and welcome to Innovative Learning Process. Now we will take General Studies. Second, the question from the mains perspective. Question is evaluate the role of remission in reducing the burden on the criminal justice system. So, our question is that what is the role of remission in reducing the burden on the criminal justice system? Examine the possible risks of arbitrary or en masse remission and suggest measures to ensure a fair and transparent remission process. So, let me explain that. One part is that role of remission. This is one part. And what is the impact on the burden of the criminal justice system? This is one part of the question. Second is that possible risks of the arbitrary en masse remission. There is also risk. Suppose that remission means to give the remission. Suppose that people who had committed a crime and after some time they got remission, but there is a chance that when they returns when they return to the society, then they can get again involved in the criminal practices. So this is also the risk. So here possible risks is also being asked. And next is that suggest measures to ensure a fair and transparent remission process. We should provide the measures to ensure that fair and transparent remission process. How we can develop such a transparent remission process? The question is that remission is important. Why? Because we know that our criminal justice system, they are getting overburdened with the cases, and the report is saying that our lower courts and high courts and even in Supreme Court, various types of cases are coming day by day, but they are getting more and more time to get resolved. Sometimes cases are going on for 20 years and more than 20 years. Sometimes the participants and the litigants, they are not alive, but the decision has yet to come. In those situations, it is better that by way of remission we can reduce the burden of the judiciary. So what should be our introduction? First part, when we write any answer, then first we should write introduction, very short introduction. Remission plays a crucial role in reducing prison overcrowding. This is the first part, prison overcrowding, to reduce the prison overcrowding, because heavy crowd is there in prisons, and this ensures rehabilitation based justice. It means that when we provide the remission, then the criminals are, it is we hope that those criminals who are getting remission, they will not involve in crime again, because they could learn the lesson from the jails. However, arbitrary or en masse mass remission can undermine public safety and legal sanctity, necessitating a structured and transparent process. Here, we should provide the cautions that it may be the case that various state governments can or any government in center can adopt the practice of providing mass remission. This should be the dangerous because it can undermine public safety and also legal sanctity, because a person has got the sentence from the court but later on he will be worried. So this is not good. Next part is body. What should be the body or the main part of the answer? The role of remission in reducing the burden on the criminal justice system. What is the role? The first role is that we know that prison decongestion and resource optimization. Heavy congestion is there in prisons. So we should adopt such measures that can make the less overcrowding in prisons, and in this way remission is best strategy to reduce the number of inmates in prisons, easing pressure on prison infrastructure and lowering administrative costs. As per NCRB, National Crime Record Bureau 2022 data, India's prisons had occupancy rate of 131.4% with 75% under trials. This is very important data. Our occupancy rate is 131.4%. It means that whatever the capacity of the prisons is there, we are having 131%. It means that beyond our capacity level, our prisons are facing the crowds. And also this is very important data is that 75% are under trials. It means that under trials means those persons where guilt is not proved. It might be the case that in later stage they will be found that they are not the guilty, but they are in prison right now. So this is not good. There should be some provisions. Next is focus on under trial reforms. While remission primarily applies to convicts, indirectly reduces burden on courts. It is the method to reduce the burden on courts, allowing space for fast tracking under trial cases. Like Justice Amitabh Roy Committee in 2018 recommended that fast tracking of under trial cases to decongest prisons, because if we are not getting the conclusive trials, then unnecessary people are getting involved in more and more prisons, and thus prisons are becoming more and more overburdened. Judicial efficiency and case load reduction. Premature release through remission reduces the burden of repeated appeals and mercy petitions on higher courts. This is also one fact that suppose that I am in prison and if I know that I have no role in committing the crime and if I am getting any kind of sentence, then I will appeal and re-appeal to the higher courts so that I could prove myself as uh, that I was not involved in the case. So, mercy petitions and other repeated appeals can get reduced in this way. Supreme Court in 2025 ruling stated that policy strategy of grant of bail emphasized that remission should be adopted to ease judicial workload. This is the recommendation of the Supreme Court itself. Rehabilitation and socio-economic reintegration. Controlled remission ensures that reformed convicts reintegrate into society, preventing recidivism. Recidivism means again they should not get involved in the crimes in society after getting out from the jails, reducing reoffense rates. So, if people are getting the chances to get rehabilitation, then most probably they will not be involved in recidivism because they have faced the challenges or the pain in the presence earlier. Example is that Kerala's prison reforms 2023 focused on skill development and phased remission. This is the good step because we should provide the skills so that they could get involved in the mainstream of the society and they will not get involved in the recidivism. International best practices in prison reforms like Norway and Germany have structured remission models. So we can also learn from these practices that is being practiced in international levels. Like Norway's open prison system allows for conditional early release based on rehabilitation. Risks of arbitrary or en masse remission. This is our concern that there might be the en masse remission. En masse remission means so many people are getting released from the jails. So this is also the risk. Or there might be the arbitrary decision, and in that arbitrary decision our justice system can get eroded. Threat to public safety. Arbitrary remission may release prisoners without proper assessment, increasing risks of crime recurrence. This is the public safety threat because if we are giving the remission to the people without having the proper consideration upon the case by case, then they can get involved in another time in a bigger crimes. So this is the big challenge for the society. Like there might be example that in 2019 Tamil Nadu remission convicts in Rajiv Gandhi assassination case faced strong opposition on public security grounds because we know that in Rajiv Gandhi assassination case, the convicts got released, but later on there might be the chances of various other vested interests, and upon the based on these grounds a strong opposition has been registered against those cases. Political misuse, this is another factor, that and vote bank politics. There might be some governments that if they are getting interested, then they can provide the remission in order to get the electoral gains. And it may also that selective releases might be done. It means that those people who have been associated with the particular political party, they can get released, and others who are not directly associated with that political party, they might not get releases. So the selective releases is also the risk in this case. Suppose that there is example, Bihar government in 2020 decision to remit sentences before elections raised concerns of political favoritism. This is the example. And next, violation of judicial authority. As I earlier discussed that court has given the sentence, but later on any government released to that person unnecessarily. It means that there is no meaning of the sentence. What is the meaning of that judicial trials? Whatever the cost had been borne by the state is for nothing. So en masse remission may bypass judicial reasoning and dilute the principle of individualized justice. This is also our concern. Erosion of rule of law and disparities in implementation. Rule of law. We should maintain the rule of law in any case. So unequal remission across the states create inconsistencies, undermining the uniform application of justice. Statewide disparity in remission policies, as it is seen in Gujarat's 2022 release of convicts in the Bilkish Bano case, has drawn criticism. There is a case of Gujarat, Bilkish Bano case. This is the murder case, and the convicts had been released, and thus Gujarat government has been criticized for that release. So the question is that is there any policy regarding this, that is uniform policy? The answer is that till now no such policy is available, so that the uniform policy guidelines can be provided to the states in these cases. Risk of recidivism and lack of monitoring. Without proper post-release supervision, some convicts may replace into crime. It means that if we have to put the check and balance upon those inmates who are getting released, so we should establish such supervision mechanism so that their activities could be registered and they could be monitored properly by the state. Like there is a report NCRB that over 15% of rearrested criminals were previously released on remission. This is the data that those who got the remission, but 15% of them are getting involved in other crimes as well. This is the NCRB data, National Crime Record Bureau. Next part is that measures to ensure a fair and transparent remission process. What kind of measures we should adopt? So, the measures that we should adopt: mandatory case by case review. This is very important, the case by case. It might be that some person might be liable that again there is a high chances that that person might get involved in the crimes again. So those persons should be treated differently. But those persons who are well established that they got involved in the crime in some or other regions, but there is a less chance that again that person may get involved in the criminal activities. So those cases should be differentiated on the basis of the reasoning. Every remission decision should undergo an independent review based on well-defined eligibility criteria. Like Supreme Court's ruling in Mafa Bhai Moti Bhai Sagar versus State of Gujarat case emphasized that reasonableness in remission conditions should be applied. Without reason, there should not be practiced of any kind of remission. This is the Supreme Court's guideline and ruling. Next is it uniform national policy for remission. There should be a uniform policy on the national level. Centralized guideline under BNSS 2023 can prevent arbitrary state level variations in remission. It doesn't mean that Gujarat government is thinking in somewhat else and Bihar government is thinking in another way. This should not be the case. The case should be that there should be the uniform policy for the releases. Law Commission of India 268th report in 2070 recommended that a national policy to standardize remission across states. This is the recommendation of the Law Commission. Strict public safety assessment mechanism. Risk assessment models should be institutionalized to evaluate potential threats before granting remission. This is important thing. Like UK's parole board model evaluates potential reoffense risk before early release. Evaluation should be done properly, that what is the potential of the particular person to get involved in the criminal activities. If there is some possibility that that person may get involved, then that should be different case. And if it is clear that that person may not involve, then that person should be treated in differently. Judicial and citizen oversight mechanism. Remission should be the subject to judicial oversight Judicial oversight is important. Like Germany's conditional release system mandates court approvals for remission cases involving serious crimes. Like we can follow that if there is any person who is involved in serious crimes like murder, like rape cases. So, before providing the release to that person, there might be some system that court's permission should be taken in that cases. Next, post release monitoring and rehabilitation support. Structured monitoring prevents relapse into criminal activity and facilitates reintegration. Like Tamil Nadu's 2022 post release probation system tracks reformed convicts for 3 years. It means that after the release of the person, there should be a monitoring system for the 3 years. Next one, conclusion. While remission is a powerful tool for criminal justice reform, arbitrary or en masse remission can undermine public trust and legal sanctity. A transparent, standardized, and accountable remission process is crucial to achieving the dual objectives of justice and rehabilitation in India. In this way, we can write this answer, and this will be the practice session 1.